the 8th of November in 1952, 13 people were killed and 78 others wounded in what became known as the Maibuye Uprising. The Maibuye Uprising was a sequence of protests and demonstrations led by the African National Congress, the South African Indian Congress, and the African People's Organization that took place around number 2 location in Galeshwe, in Kimberley. The uprising came in reaction to some of the laws put in place by the then apartheid regime that were deemed unjust and inhumane by numerous members of the community, and thus, as part of their defiance campaign in Kimberley, Dr. Arthur Litele, who was the ANC branch chairperson of the number 2 location, organized a group of volunteers to defy the apartheid laws, including the following: the Native Labor Regulation Act of 1911, which resulted in the movement and remuneration control of the African, that essentially established migrant labor and an average standard wage. 2, the 1913 Native Land Act was passed to allocate only about 7% of arable land to Africans and leave the more fertile land for whites. These laws incorporated territorial segregation into legislation for the first time since the Union Government of South Africa in 1910. 3, the Population Registration Act of 1950, which required each inhabitant of South Africa to be classified and registered in accordance with his and her racial characteristics as part of the system of apartheid. 4, it was the Group Areas Act of 1950, which assigned racial groups into different residential and business sections in white-dominated urban areas. Number 5, the Pass Laws Act of 1952, which stipulated that all people of color above the age of 16 should carry a passbook at all times when outside their designated homelands. Honorable members, I raise this in the context of the public hearings and the process that we engaged in lawmaking. We must never take for granted that immense sacrifices were made so that we today can have a just and human rights-based system as enshrined in our globally celebrated Constitution of the Republic of South Africa and our Bill of Rights. Secondly, honorable members, we must remember that it was ordinary people from various walks of life who took on the task of active citizenry by protesting unjust laws, and therefore in our deliberations in public hearings and other forums of the people, we celebrate the generations of locations, villages, farm workers, laborers, and others who rose in protest then and who even today hold that right of protest as an important instrument of democratization. Thirdly, honorable members, we must be humbly enough to acknowledge that not all public engagements, interactions, and other manifestations of active citizenry are going to be palatable or in agreement with what we as lawmakers envisage. In these scenarios, we must remember and remain true to the principle that it must always be the will of the people that reigns supreme. Fourthly, honorable members, protests are about defiance, lobbying, and making the voices of a segment of society heard. This is a fundamental right that we must protect with our lives. When protest is muffled and suppressed, our people lose their voices and social decay will set in. We must therefore remain vigilant, and we pray for the souls of those who died in the Maibuye uprising and all others who paid the ultimate price on the long walk to freedom, and for us to sit here today. Honorable members, let us proceed with today's agenda items in gratitude and in consciousness of the road ahead, which is still long, and we dare not linger. Too long, and we dare not fail. I therefore want to extend an invitation to the DG, Ntate Ramasodi, and the officials of the department who will be giving us their responses as the Portfolio Committee on Agriculture, Land Reform and Rural Development. Let me therefore, honorable members, hand over to the DG. Tate Ramasodi, good morning.
Good morning,
and good morning. Ramasodi, please hold on. I see a hand of the Honorable Ntate Masipa.
Very much. Chair, in terms of the agenda for today, is obviously, one, the deliberation, the feedback, obviously giving an opportunity to the department that introduced this bill to us. Obviously, we had the deliberation with the, not the deliberation, but we had the public hearings. And the department has got, the right to obviously come and respond to those particular hearings. But the concern that I have got is that, Chair, I wrote to you yesterday that in the agenda of today is also the adoption of motion of desirability. But we cannot really move to the motion of desirability without engaging or deliberating on the presentations that were made by the stakeholders. So in as much as we afford an opportunity to the department, Chair, it is important that we observe the rule, the parliamentary rule in terms of this particular process. So I will also quote Rule 2866A of Rules of the National Assembly that states that when in the process of inquiry into a bill, the committee must apply separate formal stages, which include 1, briefing by the department concerned, and in the case of a member's bill, by the member consent, and 2, consideration of public comments that have been received, and 3, obviously, the adoption of motion of desirability. But what the rule also say very categorically and clear is that, just want to really read from the book itself, is that the formal process, okay, it says this, in the process of inquiry, as far as possible, apply the following separate formal stages. These are the stages that I have just stated. The concern that I raised was that we are doing the deliberation with the department, but we are not really affording ourselves enough time to engage on the matters that were raised by those that made submission to this committee. So, Chair, I am really raising my hand to really talk and highlight this, that I feel we are short-circuiting this process. We should really do it one is not, I don't think that the presenters that were here, they were opposed to the bill, but they were saying, here are some fundamental things that this committee, us as the members, must consider. So I will really like to appeal, Chair, that we give ourselves enough time to deliberate on the inputs that were made by the industry. Thank you, Chair.
Thank you, Honorable Ntate Masipa. You may lower your hand. Honorable members, any other hand? If not, the stakeholders, Honorable Ntate Masipa, were given an opportunity to make their submissions, which they did make their oral and written submissions. We therefore had an opportunity as a committee to engage with the stakeholders in terms of putting our questions of clarity and comments. And we had a very fruitful engagement with stakeholders. Secondly, today is to afford the department to have responses from the input and submissions that have been made. And again, we will engage with the department in that regard, where we'll be able to have an opportunity to have questions of clarity, as well as be able to have comments in their input. I did also make the committee aware that we have our legal advisors from the Parliamentary Legal Services that are also with us, where we will have an opportunity to get their input when we come to dealing with the bill. Today's proceedings was to get responses from the department, and then to pose the question to the honorable members in terms of the motion of desirability. Because once we understand what the appetite of the honorable members is in terms of motion of desirability, we will know the route to embark on in terms of dealing now in the next following meetings regarding the bill. This is how we have outlined the approach, and we would like to proceed in that regard. So members will have ample time to engage with the responses that we received from the stakeholders as and when we make input towards the bill. But we just want to ascertain in terms of the motion of desirability, the appetite of honorable members, so that we are able to map a way forward as to how do we tackle the bill. Ntate, yes, Ntate Masipa.
Chair, I think you have to really educate me a little bit. If we move the step to motion of desirability, are we now changing the rule to say we move into, we haven't really considered carefully the public comments? And I'm talking us as legislators, you know, because we need to have an opportunity of us engaging on the public comments. And obviously, like I said, you know, the department is given an opportunity, and the rule says that, you know, obviously call it the third point will be moving to the adoption of desirability after engaging the department, and obviously considering the public inputs from the public participation. Just educate me there a little bit, Chair.
Let me bring in the educators, then Honorable Ntate Masipa, because we do have very capable people in the Secretariat in terms of procedure, but also content advisors can speak on the matter. And if we need, we can also look into our legal services colleagues. Mamu Nyamza, Mam Kakaza. may share light for honorable members in terms of procedure.
Thank you, Chair. I think, Chair, you have done a very good work with regard to explaining the process already. What Tatu Masipa is saying now, we've already done that. You've already mentioned that we have participation process whereby we have public hearings and we engage with the stakeholders there. And the second step, the step that we are in now is the response from the department. So that, as you have already explained, Chair, so that members can map a way forward. Chair, can I also take Tatu Masipa into confidence with regard to Rule 286, 4 of the Rules Committee? In terms of the rules, it says after due deliberations, the committee must consider a motion of desirability on the subject matter of the bill, and if rejected, must immediately table the bill and its report on the bill. Number 2, it says if the motion of desirability is adopted, must proceed to deliberate on the details of the legislation. I think that is where the committee is now, Chair. Being part of the meeting and also listening, observing that during the discussion, I think members, I can see that there is a need that they are going to propose some amendments in the bill. I think this is the process that is going to follow. And that means if the members feel that there are amendments that need to be proposed in the bill, that means they must first adopt a motion of desirability, and then they can proceed to deliberate on the details of the legislation. Thank you, Chair.
Thank you, Mamukakaza. Any other further input from the Secretariat or content advisors?
Thank you very much, Chair. No further input, Chair. Mamukakaza, uyibeke yonke, Chair. Thank you.
Thank you, Mamu Nyamza, Secretariat. Any bite from the content advisors?
No, Chair. The procedural people are in charge there. Thank you.
Yes. Yes, that's why I started with the Secretariat in terms of procedure. That
I may complicate it further, so I'll leave it with the procedure people.
No, thank you. I just thought you will have some wisdom to share. It's satisfying all of us as honorable members on the procedure, but this is, honorable members, the procedure that we looked into, and we asked the questions, and I was happy to receive the question from Honorable Tate Masipa, because it allows us to engage further and scrutinize the manner we are to approach the bill. So it is a proper procedure that we are embarking on, and honorable members should feel free to engage as we were able to engage with stakeholders and also put our questions of clarity. We will also do the same with the department. And then having done that, we'll then have to put the motion of desirability to the committee so that we can know which way we are to proceed. And Tate Ramasodi, let us hand over to you to proceed. Good morning.
Good morning, Honorable Chair, and thanks for the deliberations. Now we know the deliberations in Parliament around legislative overview and setting up that you have to do. With me today from the department, Honorable Chair, I've got DDG Dipepenene Sarache, I've got Ndate Bidima Kafola, and I've got Dr. Mutenge as the people who will be in the forefront in terms of discussing this agriculture Product Standards Amendment Bill adequately in terms of the engagements, the side of our stakeholders. That is AGBIS, that is the South African Fruit and Vegetable Canners Association, the South African Fruit Juice Association, the Consumer Goods Council of South Africa, the South African Organic Sector Organization, and the Participatory Guarantee Systems of South Africa. And they had followed up these written inputs with their oral presentations to the Portfolio Committee on Agriculture, Land Reform and Rural Development. And since then, what we have done as the department, we have looked at all the comments that were made, and we have come up with a presentation that we think will be responding to the issues that were raised, ranging from the protection of interest, going to ensuring that at the end of the day, the cost of recovery in terms of the system that you are putting up would not be a hindrance to the system. We have got an issue around the assignee that was part of the engagements that I think would form a larger part in terms of the deliberations. We also had discussions around organic inclusion in terms of the standards, and Honorable Chair will recall that this has been a long-standing issue between the department and the stakeholders. And with our responses, Chair, I think we will be able then to respond to the issues that are at hand. I had also sight of the comments that came from the legal services from Parliament and advice that they had for the department in terms of this. And I think that our engagements and taking into consideration what the legal services from Parliament had advised us to do would be able to advance the discussions and also guide our inputs towards this August House today. I would now hand over, with your permission, to Desirability to lead in terms of the inputs and the responses. And from there, we will have the responses amongst those who are from the department. And I think, with your permission, also legal services from Parliament to assist. Thank you, Chair.
Thank you very much, DG. Good morning to the members of the Portfolio Committee and the colleagues in the department and the colleagues in the cabinet from the support as well as the legal services. And like DG has already mentioned, the team, I think the only person that DG forgot to mention is May Tsepo Mahlaela, who is the legislation expert of the department. She's also with us today. And the Word document that is displaying, I'm just quickly trying to see if it's displaying it. Yes, it's got 42 pages in the main, but we will make sure that we do not, we are mindful of the time, and we tried as best as possible, honorable members, to accommodate all the written and oral submissions made. And we will therefore we didn't leave anything, hence we now have a Word document that comprises 42 pages. In the main, the comments are grouped, and they speak to the few issues that DG has alluded to. In the main, your assignees, your fees setting procedures, your management control system, and just one or two proposals for insertion. But I think upfront, we need to also make it a report to the committee that there were comments, most of them, especially during the oral presentations, that were not necessarily directed at the bill itself. There were also similar comments received, which were not necessarily addressing any content of the bill, but the general principle act. We therefore want to take this opportunity, honourable members, to acknowledge those comments and appreciate the interest that the stakeholders have expressed. And we will find a way of collaborating with them and go through some of their proposals and suggestions that, like I said, are not necessarily addressing the bill. Today, we will therefore only confine ourselves to responses that were, though the ones that are not addressing the bill, we will flag them, but we have prepared the response specifically to respond to those that are addressing the bill. The definition of assignee, most comments were confining themselves to the definition of the of assignee, and we really find no need for us to further define assignee more or further than we already are defining it. And with your indulgence, Chairperson, just to increase the connectivity and the audibility, I would love to switch off my camera, but will from time to time switch it on. I'm seeing on my other gadgets that I'm getting slower. So we addressed the assignee, and our really response is that the definition of assignee in its current form is sufficient, and it's not new. And the Principal Act, Agricultural Products Standard Act, has been running, has been operating with an assignee as defined, and there are assignees further, assignees that were appointed as far back as 1990, and the context within which they were appointed is still relevant today. So this is as far as the assignee is concerned. And our response on the right hand side are really just going through, engaging rather the assignee or the comments regarding the assignee. But we're saying that anyway, the definition as per the proposals, as per the inputs, will, as best as possible during our further collaboration and deliberate and engagement with the stakeholders, look into how best we can. Maybe we realize that in the main is a question of explaining and maybe the language used, but the comments, all of them really are not opposing the amendment or the bill itself. Like for instance, here, one of the at B here, one of the comments is saying, how is it possible that a person, which is the one that I want to touch because a bit there's more interest on this one. They say, how is it that a person or undertaking or a body or institution associated or with the work of the Act, how is it that that person cannot have interest? So the question of direct or indirect interest was in the to a large extent, a lot of time was spent on it. So we agree that this is correct. It is possible actually for a person or a juristic person to have particular knowledge of the process without necessarily being interested. Do we give an example of academics, for instance, who would have knowledge, who would have through research or or studies or everything else, would have particular knowledge of this section of the Act, without necessarily being farmers themselves or without necessarily playing any role in the industry. So we will just give that example to show that it is possible, because the comments were sort of checking whether is it at all possible. So we say yes, it is possible, and we give that example. Again, on the issue of whether is it reasonable to assume that basically that is the same. This one comes slightly different in saying it is reasonable to assume that the intention of the inclusion of the reference to this, again, direct or about direct or indirect sale. Again, this proposal was made to us to consider, including or inserting into the bill, and our response is no, we cannot, because the definition as is or in its current form will be able to prevent any further conflict of interest. And so like I said earlier, some of the inputs were in the main going beyond the scope of the bill, but this just goes to show the interest, the amount of interest that different stakeholders had. And as I said, if you look at D here, that says this part is also the comment that assignee should be on a cost recovery. This matter about cost recovery was actually mentioned more than 3 times by the stakeholders, and we pause here to explain that we are in agreement that the work of the assignee should be on a cost recovery basis. It means they have to recover the costs and they have to ensure that they do not compromise the work that they would be doing in the process of them recovering costs. But then it appeared from the presentations, especially during the oral presentation, that there was a bit of a challenge with the understanding of what cost recovery actually entails. And cost recovery means it doesn't have to be doesn't require any legal definition. It's just English. It means the activities that one goes about in doing the work. Those activities obviously attract a cost. And in doing the work, one has got to be able to then cover the costs. An example would be traveling to inspection points, the office accommodation, the vehicles that are traveling to perform audit or inspection services. Those are cost recovery. But the sense one got during the oral presentation was that maybe we need to further on engage with the stakeholders so that we make them understand what we mean by cost recovery. In the main, some seemed not to understand it to be meaning any other operations. So that's why I thought we needed to spend some time. But in the main, they were not opposed to the setting of the fees, which is very important. So we noticed that all the stakeholders or all those interested parties were not opposed to setting of fees, of inspection fees, or be it audit fees in this specific case as well as that. So we're citing here a case law, which is also attests to the fact that even all the pronouncement or all different presiding officers in court were not opposed to fees being set by the assignees. So that's fine, but there was a reference, and which unfortunately was not a verbatim reference to a court case. So hence we decided to bring this specific case law, and members and everybody would be able to look into that. It actually affirmed the importance of setting of fees. Or what it emphasized, however, is that the department must play a visible and intelligible role in ensuring that assignees come up with that assignees, when coming up with their fees, are transparent, are open, and the fees determination is based on a cost recovery principle. So we are in agreement with that. Again, here is a comment which is unfortunate that this came from the both oral, in fact, this was a written representation, and it says, and I would love to just quickly read it through as is, it would be preferable for the drafters to adopt the department's stance in the Meat Safety Act, this Meat Safety Act of 2000, which is mainly about the safety of meat and that are applicable to the abattoirs in the country. So it says, and give specific comments to what constitutes independence. So in the Meat Safety Act, although this version or this excerpt is unfortunately misaligned to the current work of the bill, the Meat Safety Act referred to here does make provision for independent inspectors. So I think the stakeholder here specifically either misunderstood or failed to understand the intention of the section of the Meat Safety Act that provides for establishment of independent meat inspectors. So in this specific case, when we looked into the act, the Meat Safety Act, and which is section 4, paragraph 8, it does not necessarily talk to what the written presentation seeks to address. So in the main, we therefore found it irrelevant to the process at hand. PGS, my bad. PGS also asked whether they could be, found to be relevant or be appointed to run the services of an assignee. And well, for starters, we don't even know what PGS is. That is, it's not a regulatory or statutory body, so it's in any other company. And of course, should an opportunity arise for us to have to appoint assignees, and PGS, like any other company organization with knowledge of the field at hand, would apply and would be afforded and would be considered. So It's not the fact that the PGS, a private institution operating and with interest in the affairs or in the area of organic or related, the fact that they operate in that space does not make them statutory, one, and we do not necessarily know about their existence in particular, but even if we knew about them, we are not at the stage where we are appointing new assignees. Like I said, honorable members, should a need arise, we would definitely look at consider them like we would consider any other applications. That is, should there be a need for us to have to look into appointing assignees specifically for organic certification or related services. Again, this is about an assignee that consideration should be given whether this change will prohibit or exclude expect association. This is similar to PGS, but in this specific case, dairy standard agency performs private services to the dairy industry, and even though they are being paid or used loosely the term paid through the tariffs, it does not make them a statutory body that would be that could be considered. In any case, the Act as is makes provision for minister to appoint assignees, and this assignees would be like we've defined what an assignee is. Assignees would be those bodies or juristic persons or institutions with expert knowledge, yes, but that does not mean dairy standards agency automatically qualifies for consideration. But in the event of any need arising for us to appoint an assignee, another additional assignee, this will, of course, will be based on the work that would be doing, the volume and the amount and the extent of the areas that needs to be covered. Should, like we've done in 2017, 2016, 2017, when we added additional assignees into the field, should we, as and when the economy grows, as and when the work happens, should we there be a need, we would, in a transparent manner, approach and call for applications. And if there is standard agency so applies, it will be considered. But this does not make them any better or preferred institution, like in the same way as the PGS above is not. Again, on assignees, again, the comment was that definition should be expanded to include the assignee, the wording that says the assignees must be a juristic person. This we have addressed, and it's currently actually addressed in the Principal Act, Section 3, Section 2, Subsection 3, Paragraph A of the Principal Act does explicitly address this comment. Probably the stakeholders were not aware, but we're referring them to that. But again, like I said, as and when a need arises, we will engage with them. We're more than willing to re-engage even as soon as the process concludes, or at any time, if the committee so direct, we are ready to re-engage them. But we found it that we're referring to this section of the Principal Act. It does really cover the input as made here. Again, that direct and indirect interest in the product consent. Again, we responded this when I responded to direct and indirect access, where I made an example of an academic institution or academics or in the field. We were addressing the same comments, but we specifically decided not to lump it with the other because we wanted to make this example. For instance, the comment was saying members of the PPC board are comprised of industry nominated representatives, and these are appointed by the minister. What the stakeholders failed to articulate here, or perhaps they don't know, is that PPCP itself, before it becomes an assignee of the department, PPC is itself established in terms of its own act, and it is an act that certifies or is in charge of the cold chain regulations of products, regulated products that are exported out of the country. So for that reason, PPCP, even if the assigneeship of PPCP is withdrawn, PPCP will still perform its role as per its founding legislation. So I think probably the stakeholder was not aware of the dynamics or how PPCP comes into the beam. But I think I understand why, because the PPCB is often compared with other assignees like the PROCON or dairy or Agency for Food Safety that does dairy, that does poultry. Those ones are independent juristic persons, independent organizations. They're different from PPCB. The only commonality between them and PPCB is that they are, all of them, appointed as provided for by the same provision or section of the Agricultural Products Standard Act, but that does not mean they are the same as far as their formation and the work that they do. Like I said, PPCB's work, other than it being an assignee in terms of a section of the Agricultural Products Standard Act, PPCB is still a state SOE of this department. Again, this we responded to the above, so we just mentioned, we made sure that we don't leave anything out in this weight document, honorable members, so that we make sure that we with a fine comb, in inverted commas, go through all the comments. So we didn't leave any comment out. So we articulating them here, but we, in the main, like I said, when we started, they are addressing similar, or they are making similar comments, and they are addressing similar part of the bill. So we responded to them. In the interest of time, we responded, for instance, where if just one just takes that this one, K, it is prohibited that A, the amendment bill be amended so that it conveys the message that an assignee should not have any commercial interest. That we responded to. Of course, if once appointed as an assignee, their work before appointment rather would have looked as whether they've got expert knowledge of the area of the act that they would be playing, of the regulation that that they will be playing, would have ensured that they have the knowledge, the necessary knowledge and necessary expertise, and then they are appointed. Once they are appointed, their other interests, they should not, obviously, will not have any role to play in the work that they would be executing, that of being an assignee. So this is addressed above, honorable members. Or up to M, this were responded above, but like I said, they are addressing similar part or sections of the bill, so we address them above. Now, the slightly different matter is about the management control system. This is the main insertion in the bill. It's main because, in fact, that's what informed the amendment, the bill itself. Because when we wanted to enact regulations that would have been taken care of the new emergent practice in the field that we thought we were regulating. This was about the organic, free range, and related new methods of production. When we wanted to regulate over such, we were found to be acting outside the scope. That is, we did not have sufficient provisions of the current act to work, to perform the very work on the management control system. So this is the main insertion. So the comment here says, we need to clarify the span of control from where it starts and to where it ends, and throughout the value chain. And our response is basically simple, that it's a system that addresses itself to the manner of production. Now, what do we mean? If a company produces something, a product that it calls organic, we need to make sure that first, after all of us know, but we would have defined what organic is, what organic production is, but we would have to ensure that the production of organic product, let's use an example, X. If a company claims to be producing organic X, it means we need to ensure that indeed the production practice is different from the normal common practice, and this is an organic egg production. In this specific example that I've given, it would mean it will go into the feeding practices, activities, the production itself, scientific and otherwise production of the chickens and production of the eggs, which would go into the feed and related. So that is we would have to ensure that we go through that process check and audit. That's where audit comes in. We'll get to audit later. But so the span of control, now addressing specifically to this portion, the span of control is throughout the value chain, as long as it's part of the production. It stops when it becomes sale. But when we do management control system, we'll be looking at the production itself from A to Z of the production system. And then once it's done, and then it goes into the next level, which is sale, and then it invokes other the references as far as sales concerned. So the management control system addressed specifically that, the manner of production and associated with the claim. The claim in this specific case would be organic X. So if a company or if the producer claims that the X are organic, we then have to ensure that we go through the management control system to ensure that ordinarily juxtaposing that against conventional production, this claim can be confirmed that X are organic. That's basically what this is. So again, there was another one that says management control system should only be applicable on the local and domestic markets, domestic market. And they say it should apply to products that are only used for inland consumption and for great. We don't know why would they prefer to do that, but safe to say that the Act or the South African law is in the main designed to regulate processes and activities within sovereign South Africa. Now, anything that is sold, any product comes into the country, it will have to match and it will have to be taken through the same process that the local production product would have been taken through. Now, this comment seems to be saying only for the domestic sale, meaning the production that is to be produced for export should be excluded. But here is the challenge if we were to consider that. Not all the products that are destined for export end up being exported. There could be a number of reasons. It could be that they do not meet other requirements of the export and related. And these products end up getting sold locally, and there's nothing wrong with that. So we cannot have, for instance, oranges that are, this is orchard that produces oranges for export only. It's not possible because whatever production that happens has got to be subject to the provisions of the law of sovereign South Africa. So it has got to comply with the production law of South Africa. And additional to that now, which is secondary, additional to that, of course, there's got to comply with the market if it is a product that has got to be exported. So in this specific case, it's practically impossible that we can have production that is only geared toward export. It's not possible because the law of South Africa is about regulating South Africa, in this specific case, South African agricultural production and the quality and associated other work and the activities of agricultural production. So it's not possible. But in the event the products have got to be exported, of course, first they have got to comply with South African law. In this specific case, management control system and other applicable provisions of the current law will have to be complied with. Additional to that, then we can look at the export requirements, which differ anyway from time to time. Again, the PGS produce is labeled PGS certified organic and PGS organic in conversation. Basically here they're saying the PGS, like we alluded to above, which is about organic production, they say PGS organic in conversation and in conversion, and it's generally recognized well and good if it's generally recognized. We got no qualms about that. What we would do still is to subject the production, the PGS products or the claims, once in this specific case, the claim is made is organic. So it means we'll have to subject the products from PGS to the management control system as we would with any other product. So if additionally they label their products with PGS certified, well and good. That's just additional a surety, and we would welcome that. But that cannot replace the statutory role of the work of government. So that still continues, because if the danger of us limiting or lessening the statutory role of government to the volunteering organization is, should they decide not to continue, then there will be challenges. So we would continue. So I think we want stakeholders to understand, honorable members, that government does the minimum requirement regulation, food safety, quality, and everything else. And if other companies or producers feel to, wants to further on enhance and add on to the minimums of government, by all means, we would appreciate and welcome that, as long as the first regulations or the first work is that of government. Moving further on, again, still on the management control system. Again, we spend a little time here because these are critical, even though others are similar, we feel, honorable members, that you will bear with us just to spend a little bit of time on this ones. For instance, this needs to explicitly include religious certifications such as halal, for instance. And we say, no, that's not to the extent that halal, if halal products and other products, religious or otherwise, are associated with, and they change if halal product is supposed to change the production system in principle, basically we wouldn't have a problem with that. But again, halal here is not different from certified organic by PGS above. That's the one before this one. So these are the same. So as long as the halal products and other products that may use the religious connotation of certification or associated with the methods of the products, such may be regulated. We'll have to continue to regulate them. Again, I'm using the example that we used for the PGS certified organic. One would assume they would have it on their products or on the individual products or packaging. There's nothing wrong with that, but they've got to first comply with the law of the country. Again, here is a proposal for rephrase. I don't have to read through that. Basically, they are, basically they are proposing a rewording of the section. But we are worried that if we were to accept the rewording, would basically complicate and also it would actually take us out of what we're trying to improve in our principal act. Like I said, basically, when we started, that we wanted to start covering the work on claims such as organic, such as free range and related. And in the process, we've had to explain what we mean by assignee, which and the management control system and related. So this is unfortunate. This unfortunately won't assist, because this definition, it basically just reinforces what the amendment amendment states. Therefore, the definition captures basically the amendment that we have. We don't know what was it that the stakeholders here wanted to achieve, but it does not really change anything. It will still, even if without this, the primary objective of the bill will still be achieved. Again, on management control system, they're saying this stakeholder at F, it's saying it's not clear what is entailed in the examination of the management control system, as the term is not clearly defined. And we have defined it. I think that's where I said when I started, one of the members, that there may be a need to have workshop further on, just to clarify it, because the definition relates to the method of production and the use of associated claims for the product thereof. But it does appear that this stakeholders or interested party seem not to understand this definition, which we think is very clear enough to be explaining the method of production, which is associated with the claim. If, for instance, the method of production or the product is claimed to be organic or free range, for instance, we would have to, the management control system will be us looking into whether the production adheres to what is termed a free range in this specific case. So we don't know what is unclear here, but I think it may just need be a question of a workshop. So once the bill is ascended into law, or even if this committee so wishes that we could do it another workshop, we're ready, we can do it, because we sense in the main, honorable members, that there may just be a question of a misunderstanding of the concepts. Again, at G, the extent that envisaged audit, which is very critical here of the management control system, is expected to guarantee. When you audit in the main is, are you doing that which you said you were going to do? In this specific case, audit would be you saying to produce free range X, you are going to do A, B, Y. And we would have gone into the science and ensure that A, B, Y gives us free range. Now, what is audit? Audit means we then come and ensure that A, B, Y, you're doing A, B, Y that you said you were going to do, A, B, Y that we are in agreement with you that A, B, Y ends up with free range X. So if the stakeholder here do not understand the extent, I think that's one area that we think we may want to just basically have a bit of a workshop and ensure that we make them understand. But there is basically a clear alignment between the acts that they mentioned. This is the act that is the FCD Act, is administered by the Department of Health. So in carrying out our activities as part of agricultural products under that Act, we interact, often. When we have got to our Act, compel us to interact. That is that of the Department of Health, FCD Act, and our Act, APS Act. We have to, because it's about food regulation. There's an area beyond which it becomes the mandate of foodstuffs and cosmetics and disinfectant Act of the administered by the Department of Health, and the area that we operate under agricultural products under the Act. So our acts really do complement. I think again it's a question of misunderstanding, we think. Again, management control system. Again, so there's an insertion of the revised definition of management control system is not supported. Okay, claims are governed through foodstuffs, which is not true really. The claims are not necessarily all governed by the FCD Act. This is the FCD Act, is the act that is referred to, which is administered by the Department of Health. So there is actual alignment between the Act mentioned, and that whilst they focus on consumer protection and even to some extent ensuring fair trade practices, the amended definition, our management definition control system, will contribute to the consumer protection and fair trade, because once the products are declared free range, obviously the price asking becomes a bit increased above the normal. Free range, as we would all know, the free range X seems to, the price asking is a bit more than normal, or no, maybe not a bit, more than normal. So ours, once we do that, the consumers would have, once we have this bill and centered into law, and the management control system and the claims that are made are audited, and we are happy and everybody and understand what needs to happen, consumers would be afforded an opportunity to choose whether they want to pay more for the so-called, well, in this specific case, for free range or for organic. If they so wish, we need to give them the assurity that indeed what they're paying for is indeed organic as per the claim, or is indeed free range as per the claim. Again, just also for members, I also think this is intelligibly clear that we then group them in terms of the comments, like we would have grouped them here. We've done them all the way. These ones grouped here under 1.3 were addressing the question around audit. We're done now with assignee. We're done with management control system. Now we come to audit. They're saying the clarification is sought for the intention of the inclusion of reference to audit. They're saying the description of the intention lacks clarity due to the fact that the reference is made in order to fully address what was intended and not an explanation. But audit and is also defined in the bill. It is, again, like I said, that which you said you are going to do. So as with audit, that's basically the simple definition of audit is, are you doing that which you said you are going to do? That which you said we are going to do, we would have agreed with during the management control system, checking whether if you do ABY, like I said, as an example, you end up with free range eggs. Fine, we agree. We register you for free range eggs. Then we come audit, which is us checking whether, this is the second layer now, the third layer of the process. We check whether the process, that which you as a method, recipe, for instance, if that is the recipe, are you following the recipe, the method of production? Then that's what audit. And this is different from inspection. Inspection and audit are two different things, because inspection would be at the end of the product to check whether the product complies with what that which it has to comply with at the end. And audit is not necessarily at the end. Audit is throughout the value chain. Clarification at K now on whether the audits are intended to be limited to cases where the requirements, other than the requirements as captured, for example, this is the regulation that we published, which cannot be determined by technical testing. There again, we use the example, free range as an example is a manner of production which results directly under the management control system and will be covered under the same. However, this geographic indicator, in this case, we use an example of a Karulan. This is a different claim. It's not the same as one would claim and assist a method of production. This is, for instance, Karulam. This is a geographic indicator. It means it is accepted and registered as such that it's produced at this specific area, and there's a difference to this, drastically different from a basic free range production, like we used an example here. Grouping this once again here, this they give us we're still under the audit. We agree with this one, the J, which say audit in respect of products of which compliance with the relevant regulatory requirements can be determined by testing of the products will not, so basically we are in agreement that hence audit will only refer to the management control system. So any other thing, there will be inspection, there will be audit. Audit, we are auditing the management control system like we alluded to above. So this is basically we are in agreement. Again, on audit, we couldn't really clearly understand what PGS intended to establish here, because they're saying, would the PGS audit process by other members of PGS group be considered independent examination? Basically, we think they wanted to check whether if PGS has its own inspectors or its own systems of confirming. Remember we said the PGS said they certify their own products as a certified organic. So the understanding here, we think they're asking whether we would basically accredit, for lack of a better way, to accept their self-auditing. That's basically what we think they're trying to do. So we couldn't find clarity. We'll still do that, but if that is the case, I've explained above. They can do it, and we encourage them to continue doing their self-auditing of the management control system. Find themselves, we find with if they continue to do auditing on their own, but that still would not replace the work of the statutory work of government. Excuse me. So that's basically our take. Here it's not clear who will be doing audit. Again, audit, I'm not sure why they're saying it's not clear, because if you look into the Principal Act, there's inspection, for instance, and the Act does not necessarily, from definition of inspection, articulate who does the inspection. But the intention, the expectation is that once it's a part of work, statutory regulatory work of government, it means inspection is going to be done by government. Whether government does it in the form of assignees or self-appointed inspectors, I think that shouldn't be a question for a worry, because that will still be done. And like I said, the minister may decide to appoint an assignee, which is fine. It will still carry out audit, or can use the current inspectors, depending the areas that has to be covered, the capacity, availability, and related. So we not, if that intention was for them to check, especially when they talk of separation of powers between inspectors and auditors, they really are not doing the same work. But can inspectors do the audit? Yes. But they will just have, when they go out or they carry out an audit, the work differs from inspection. Audit will be auditing the management control system. So it may even be in the middle or the beginning of the production value chain. Inspection, not necessarily. Inspection is at the end product. So that definition answers comprehensively or the question on whether the audit and inspection can be interchanged. No, they're different. The definition of audit should be aligned to the definition of the ISO. This is the ISO 9001. It's basically a very good guideline. It's not statutory. So it basically means accreditation of the methods in this specific case. If, like any other system, since it's not a statutory, it's not compulsory, if it's done, well and good. It cannot replace government. Of course, if for companies that are ISO 9001 certified, the expectation is that they would be very organized. All the benefits out of that would be that it will be quicker. It will be quicker for us to perform audit action on ISO 9001 certified companies, because assuming again that they are adhering to the dictates of ISO 9001, but it cannot replace government, the work of government. Again, this the act. This is okay. Let me just go a bit back here. Yeah. Okay, we covered this one under the ISO. Yeah. So the proposal to define claims to be included. Again, I think I spent some time on this one. Honorable members will remember that we said a claim is the statement that you make, the quality statement that is made. That's a claim. Maybe they understood claim differently, but again, we are willing to re-engage. This is the statement made about the product. So if you say free range, that's a claim. You're claiming that the product it's been produced differently from conventional production. That's what claim is, and it's clearly defined. But we'll be able to. I think we are willing and more than willing actually to re-engage and make the stakeholders and role players understand the intents and intentions of the bill, and hopefully ultimately the amendment of the act. Clarity is needed on whether an audit or management control system will only be conducted at selected facilities. No, we answered this one. I think in the main I answered it comprehensively. At what stages would we be conducting audit and how that differs from inspection. And here, the introduction of the defined term, again, is about audit with amendment to the definition and our insertion. This insertion in the bill is vague. Yes, so that's a very valid observation, but it's not necessarily vague, but we understand where they're coming from. But in fact, we are showing them to section 3A, subsection 1 of the Principal Act, which sets out the basics of inspection. And where there we are explaining what that is, and the audit relates to the management control system, like we've been saying. So there's no need to further define inspection, and because the inspection remains the same. So management control system, we have vehemently and comprehensively been defining it throughout the bill. Again, this is about the audit. This is just sound like I said when we started. Some comments will really appreciate them, and we appreciate the interest shown. Would definitely engage, and some of them will just mean we may want to, maybe in the form of regulations, further expand and make it clearer. But those are not things that necessarily address the bill itself. And then here the input critical is that the proposal is for us to delete claims associated with the product, and that it should be replaced. we really do understand, because the method of production in terms of the grades and classes will still fall under the same section. And if you read it in conjunction with the Section 3 of the Principal Act, products have still to be classed and graded. So even when it's organic, for instance, this is what it's explaining, even if it's organic or free range, it will still have to comply with the grades, class A, class B, extra class. That does not change. This we responded to in detail. So we just brought it here so that we comprehensively show where we're coming from. Now we come to cell. Clarify if any person would include a storage operator of grain and or what basically this is about the definition of cell. And to simplify, cell is presentation of a product for whatever purpose. So yes, at this question about whether it includes storage operator, we say yes, it does, because this you're now presenting the product out for whoever, but that presentation of the product qualifies and falls within the definition of cell. Next one, consideration is to be made to the impact of this definition. Yes, obviously, any new law and any change in the law would have to some extent, impact. So impact of this definition to the food loss, waste and donation of surplus goods, government assessment of, yes. Here I think the stakeholder here is worried about products that may not necessarily comply, and as such they will be rejected. But we don't imagine product being rejected for them not falling within the dictates of free range, for instance. They may just be declared not free range, and such would not be rejected from sale. So food loss might not necessarily arise from products failing to comply with the dictates of, for instance, free range or organic. So I think here it was just a caution, but we take it to heart. We'll try and accommodate it as best as we can in our regulations. But in the main, the new or the bill would not necessarily lead to products being rejected for sale. It will just lead to them not being certified organic or certified free range or the claims. But that is not necessarily a quality issue, because the products will still have had to comply with other requirements. See here again, these are the on the left. These are the stakeholders that commented. So we group them so that we transparently show which ones we are referring to. The proposal is to define cell as follows. They include offer, deliver, or prepare for sale. I think they wanted to remove a very critical component of the definition, which is advertise. Either they made a mistake, in which case we don't think they would have offered this definition. So we understand that they deliberately, in their definition, wanted to exclude the critical operating word advertise. So we would not accept, because it then will just work against the ideals of the bill. The bill provides for an overly broad definition of sale and includes transaction in respect of which no consideration is received. There does not appear to be a rational basis to some extent, but it depends on the angle, because we say there is justification and rationale to amend the definition of sale to ensure that we accommodate different contexts under which the sale happens. Like I said, presentation of a product, once the product is presented to the next person or for the next activity, that's sale. So we may just want to further understand what the understanding is, so that we can simplify it. I think also there's an offer for the wording assistance by the Parliamentary Legal Services. So they also offered to help us. It's basically here it's about the English and the sequencing of the English words. We just have to, we have accepted the assistance there. We'll make it simplify, we'll make it simpler, assuming that it's a question of the language complexities. I think we covered cell in the main. Cell wasn't that complicated, but critical is to specify if donations and sponsorships fall within the definition of cell. Cell, it means now that is the step-by-step intention of the production. So you produce to sell, you produce so that it goes into the value chain. So if that is the case, then donations would not be read into the word sell, because donation would not be part of the intention of the products. There won't be products that are, it's very rare that you have products that are produced for donation purposes. But that's our understanding. And if the understanding is exactly as we do, we then are agreeing the donation would then necessarily fall within the definition of sell. But we do concede, however, that the term or otherwise should be removed so that we differentiate between donation and ordinary sell. So we'll obviously then remove or otherwise in the definition of sell. The cell is ambiguous. I think that's where the Parliamentary Legal Services would also assist us in the plain English. We were told that we need to make sure that the language used becomes plain English. Would accept. We actually have accepted the assistance from the Parliamentary Legal Services, and they will assist us present this bill in as plain English as possible. Assignee. This is from ECBIS, and the legislation should allow. Here we hope our understanding of and this is also was done also through the oral presentation. So we think at the time when we drafted, we weren't sure until during the oral presentation this came out clear. But our response is simple, that the Act accommodates the comment. So if you look at the designation of laboratories or assignees in the current Act, as well as the regulations that are published, subject to provisions of the Act, this is covered. Maybe they just may not, ECBIS did not see it, but it's there. Again, this is one of the areas that, like I said when we started, that some of the comments were not necessarily addressing the bill. The bill actually is just introducing less than about six insertions into the Act. So this is one of the areas that, though we would want to entertain it, but it is outside the scope of the bill. So this just calls for further discussions throughout refining and ensuring that we find each other with the regulatees. But it's really outside the scope. But we're not checking it out. We will keep it and ensure that as and when we promulgate regulations, or as and when we perfect the work, we will look into it. But basically, the state minister must designate a participatory guarantee system. For instance, like the example that they gave, like the PGS, which fine, we could look at that, but that's not what the bill is introducing. Definition of assignee, and this clause have material differences, knowledge and independence. Not necessarily. There's no reference to the word independence in both the bill and the Principal Act. We don't know where they read this from, but at least we know that the bill and the Principal Act do not necessarily address that. This one again still comes from the grouping Consumer Goods Council of South Africa. They are saying it is critical that a skills audit of the current and future assignees is conducted. Again, this is outside the scope, or alternatively or conversely, obviously the definition of the assignee says talks to suitably qualified or with knowledge, and so it's not, it safeguards a possibility of appointments being made of assignees who have got no knowledge of the area or of the product concerned. So we don't know what informed this, but it is addressed really. Even the current assignees are appointed by the same provision, and this work is addressed. Criteria for the selection of assignees should be made public. Again, this is clear. In the Act, it says suitably qualified with expert knowledge. So it basically, in short, in one short paragraph, explains the criteria that ought to be followed when an assignee is designated. Basically, here again, still from Consumer Goods Council, the playing field needs to be level so that the levels of retail are inspected. The former, again, the law does not make any distinction in terms of the inspection. So inspection can happen anywhere, at a big retailer, at a small retailer, at any place, and if it's inspection, it can happen. If it's audit will have to specifically start at the start of the production value chain. So we really think their concerns are covered. Probably they were not aware of the extent of the work of the regulation under this Act. Assignees to consider the quality management system. Yes, the issues raised, this has got no reference or resonance in the bill. Again, this is one of the areas that we can engage, but it's not addressing any part of the insertions or any part of the bill. Again, this one also needs to be borne in mind that retailers currently have quality controllers, well and good, same as PGS, same as any other ISO 9001, well and good. We encourage those, but that cannot replace the work of government. Amendment of clause 2. This is very critical from PepsiCo. They propose that this clause 2.3a, which is they are proposing that it be amended to simplify it. This amendment of this one, which is about really the management control system related to the product, and likewise, so it was unclear. And when we went through it for a second and a third time, we saw the point. So we concede that this section, specifically this section B, actually, even if we remove it, we're not changing anything. So we've decided that this section be removed, this new proposed insertion be removed. Because once it's removed, it then, or deleted, it then brings the understanding easier. And this is one critical input that we accept. Though in its current form in the bill would really not have done much, but we understand that it does to some extent bring some confusion. So we then juxtaposed the product of it removed or staying. So I think if we resolve to have it the clause removed, which is the new insertion. So then everything else that follows would be talking to this clause. I think at the end we'll just bring members to this clause so that we see what it was saying, what it says. But we agree to have it deleted. The new insertion, this clause. So once we agree to remove that, we still want change the direction or the scope of the bill. It will still the intentions and will still be the same and will still be achieved. So if we remove it throughout, then these inputs become no longer necessary because we'd have removed the clause. The South African fruit and vegetable canners, they are proposing that clause 2 be amended. Basically, they're saying canned fruits and some vegetables products are already inspected by PPCB. Again, PPCB inspects them for export. And those that do not qualify for export, they will be sold locally. So it's not possible that you then may say, because you are picking for export, you do not necessarily have to comply with the local laws of the country. So this proposal we spoke to earlier it was where it's about whether that which is being prepared for export ought to qualify or to comply with the laws of the country. And the answer is yes, it has got to first comply with the laws of the country and secondary to export. And in the event it does not, if the products are not found to comply with exports, they obviously would be sold locally. So the intention is for them to also be found in compliant with the current the laws of the country for local production as well as import. This is I think this is a continuation of the first part that we've addressed. The industry will not be subjected to both inspection and audit. Unfortunately, they will, because inspection and audit are two different separate processes. So the input was that they shouldn't. So we should. I think the intention maybe trying to save costs. Unfortunately, we can't. It's not. We don't have any maneuverability around this one because, like I said, audit it's throughout the production system, the production value chain. It may even be at the start, middle, in other point. So we cannot replace audit with inspection and vice versa. This one seeks clarity on criteria for selection and appointment of assignees. We deliberated, but basically they're saying that there's 2 assignees that were revoked. So they seem to be saying selection or appointment of the assignee was unqualified to conduct inspection, 5 years. The reasons why they were revoked just qualifies and also shows that the department is serious about performance of assignees. So if assignees, though they might have had during the assessment prior to appointment, might have shown quality and related expertise and attributes, if we find during the process of them performing the activities that they are showing short or they do not, their performance is poor, we definitely will revoke. We have ministers recommend to ministers to have such revoked like we did here. But that the revocation of the appointment does not necessarily mean they were not fit for purpose, which is what this input seeks to highlight. See, this one from Tiger Brands Limited seeks to clarify that it will not be subject to both inspection and audits. With this we addressed above. Unfortunately, once we bring in audit, audit is a separate activity, is an activity separate and different from inspection, so we cannot avoid that situation. So these comments here, they are not addressing the bill. This one seeks clarity on the criteria for selection or appointments of assignees, the extended to employees of assignees. That's not what the bill seeks to bring into or seeks to brings in any new insertions. Basically, these are comments which we'll look into, but they are not addressing any portion of the bill whatsoever. Again, this is the clause 2 insertion of this. Is not supported. Mainly reference to this we agreed to above. We removed the clause. We are proposing to have the clause deleted. Apologies. So, amendment again, mandatory inspections need to be carried out by designated inspectors or officers as part of the regulatory process. We thought this is known, but now when you come to, this is supposed to be known by all role players and interested and affected parties. But this clause seems to say, to attest to a difference in that knowledge. Where self-regulation of product standard is implemented with success, the role of assignees become a duplication. I think this members can already see the pattern of the industry that seeks to ask that where they are doing self-regulation, that they should not be regulated. We liken this to a situation where if a speed limit on a motorway is 60 kilometers per hour, that there be no, because everybody is supposed to, they know they have to drive at the 60 kilometers per hour, and everybody fairly seems to be knowing that regulations must not be in place. So it's still, we still have to regulate, and we applaud those that are able have systems in place to ensure that they adhere and are, in fact, they have standards above the minimum that is set by government. We really appreciate them and commend, appreciate those organizations, but the work of government, unfortunately, cannot be replaced by such. The rephrasing, this we responded to. They say we must rephrase the designation or designate having particular. That's when we're talking about an assignee above. We really responded adequately to this one. Then we come to clause 3, which is the last critical part of the presentation or the bill. This is about the setting of fees. So the Act Bis is saying fair and transparent cost recovery system and the structure. A clear and transparent process must guide the consultation. And we in agreement. We refer to the court processes, wherein the court, even up to, I think, a senior court, agreed that, or confirmed that inspection or assignees can set fees, but that government, in this specific case, the minister and the executive officer of the Act or the registrar of the Act must ensure that for lack of a simpler word, supervise the process of setting of fees. These are the cost recovery fees. So we are in agreement. This is going to be done. In fact, the bill specifically strengthens the work of government in as far as setting of bills of inspection fees is concerned by the insertion of this clause. This specific clause addresses that. Milk South Africa, it's asked that section 3, which in the main clause 3, be section 3 of the Act now, be expanded to include the requirement that each assignee should annually make audited financial statement. This is provided for in the bill anyway, so we're in agreement. In order to make this again from the Milk South Africa, in order to make it possible for interested parties to assess to assess the success of the implementation of the cost recovery, that then becomes something else that the bill unfortunately does not. It's not within the confines of even the Principal Act. So I guess there are other government processes that they constitutionally acceptable processes that the Milk South Africa can follow if they want to look at the success of the process. But that unfortunately cannot be done within the confines of the Agricultural Product Standard Act or this bill. So it's beyond the scope of the bill anyway. But the comment is so noted and would obviously be kept and kept carefully, and to address it if and when there's a need to. But at this stage, the bill in its current form does not necessarily address that. Each assignee should basically, these are the same. But this part where they're asking that the assignee should present a draft budget, this is provided for in the bill. So maybe they did not see it. No motivation is provided why the executive officer should be the sole judge, or whether, basically, this observation, we agree with it. Maybe this our intention versus what is practically in place. So where they're saying the executive should be the sole judge, and whether or not a person or party is directly affected by the actions of the assignee. What happens now if the actions of the assignee negatively affect a business? So this is what they're asking. Who are in the opinion of the so if we remove this opinion of the opinion of the executive officer, then everything's covered. So we agree, we'll remove it. It shouldn't necessarily be up to the opinion of the executive officer, but it should be. But there is appeal processes built into the bill. And even in the Principal Act does have established that there are provisions, clear provisions for appeals in the event the stakeholder or work organization is not happy with the action of the assignee or executive officer, for instance. So once we remove this, it makes it easier then, and it also ensures that the executive officer does not have the potential to abuse his powers, her powers. 3.3, this we are at page 23 of 42, but the others 21 of 42, so should be quicker from here. I know this has been long, but it's because we in the main try to ensure that we cover every oral and written submission, so that we do a thorough justice and thorough assessment of the comments made. This one is from PPCB. In the main, PPCB is asking that it be allowed not to comply with the section of the bill that is about them presenting their fees as is expected of the other assignees. The complication here, or the difficulty or complexity rather, here is because PPCB is apart from it being an assignee in terms of this act, it is a state-owned entity in charge of cold chain management. But this is it applies to the law. There's that section of the bill which is about fees and presenting them, the annual fees and transparency and related. We are unable to exclude PPCB from that for as long as PPCB plays this role of becoming an assignee. So it will be subjected to all the rules that other assignees are subjected to. Consumer Goods Council determination, this fee determination must comply to set rules. The law is very clear, and there's also case law about it. So we think this sufficiently addresses their concerns. This we responded to where we propose that the consultation process should not be a subjective process either in the opinion of the. We removed that in the opinion of the executive officer, so it addresses the concern. The comment here is we propose that the section should, so the amendment, a proposed amendment of the section of the clause that the executive shall present the business plan. But I think what the stakeholders here fail to understand is that the executive officer is a delegate of the minister. So we cannot separate the executive officer from minister, meaning in other words. We therefore implore the portfolio committee to consider requiring the fees charged by inspection, the assignees be regulated, given numerous, of course, the fees are regulated in terms of these provisions, and they would be set in a transparent, open, transparent manner. So this is clear, and maybe they were not aware. PepsiCo is saying it's unclear whether the process outlined in this section is intended to be in addition to the current, but we say the very section that they are referring to is mutually reinforcing the determination of fees. Basically, there's no disagreement with regard to whether fees ought to be determined. And there's also no disagreement with regard to whether inspectors or assignees should charge fees. So we are in agreement. All the role players, the stakeholders, all the parties or organizations that made representations are in agreement, actually, honorable members, that fees ought to be set, for cost recovery fees ought to be set. We are all in agreement. The courts have also affirmed that all that needs to be done, as per the court's directive, is that the department must be fully involved and supervise the process of setting of cost recovery fees. So once that's done, this comment by PepsiCo, it's addressed, because that's exactly what the department is going to do. PepsiCo again is saying it's unclear whether this section process, but it's the same. In fact, it's this about the fees. So once PepsiCo, if it were to look at this section, they would understand that therein lie responses to their proposals. Amendment of clause 3, again, same. And now the 3.7 is against the South African fruit caners and vegetable caners. Amendment also making proposal to amendment of clause 3. We responded to the same, again, because we understand they did not do it at the same time, but we also appreciate the interest that they have showed. So from different angles, they were looking at looking at different same matters of the bill. So we really do appreciate that, but we've responded to them. But we simply listed them here so that they are comfortable. They will be comforted in the knowledge that we really did consider their inputs. So we didn't want to just list them without specifically verbatim recording their proposal. Cost recovery here again the same, still under the vegetable canners and fruit and vegetable canners association. Again, cost recovery, which we've alluded to. So there's no possibility of over recovery, which is what they are cautioning us against. Cost recovery, the very method that is going to be followed by setting of fees would be done within the realm of cost recovery. So within cost recovery, the over recovery it's not intended. So it shouldn't. Does that mean there wouldn't be a little bit different seasons would differ, but in the act, the cost recovery is exactly cost recovery and it's transparent. So we would be able to know how much they made in the activities in the form of income, and that gets juxtaposed against the costs. Tiger Brands, again, this is the amendment of the clause that we agreed with them, the clause that we agreed that we're going to delete. So once that clause is deleted, all this then no longer becomes necessary. Once we delete the clause, these are not necessary because they were comments against the clause that I said we agreed that we will propose deletion. ACBIS is talking about the 3A of the Principal Act and of the bill that should make provision for specifying who pays for what by means of regulations issued by a minister. Of course, the bill, once assented into law, would be amplified and made easier by regulations, we agree. Insertion of the word test in substance D, it's not new, it's been there. We don't know how they were reading, we don't know which version of the bill they were reading, but the word test is there, it's always been there. Preference should be given to modalities where existing structures are optimally utilized. Again, that story, the same situation with ISO 9001, with the certified organic by the other organization. So consideration, not necessarily, but it will not be ignored. So if you are an auditor, you go into an establishment that is ISO 9001 certified, obviously you would find your documentation and related proofs sequentially filed and related, so it just makes auditing easier and quicker. If for instance, auditing is charged per hour, theirs will just be quicker because so they might just benefit if it's charging per hour because theirs will be organized. But that does not mean theirs can replace, their process or system can replace the work of government. Again, the comments here by Consumer Goods Council of South Africa, we don't understand where it comes from because they're saying the Act deals with compositional requirements. We do not agree that food safety and quality should be included as these are regulated by the Department of Health. Again, maybe they are misinformed. The Food and Cosmetics and Disinfectant Act of 1972, administered by the Department of Health, does not really cover the scope that is covered by the Agricultural Products Standard Act, which is about the quality in the main, the quality of agricultural products. We don't know, but we would certainly maybe engage them bilaterally to understand how they arrive at this. But anyway, this comment does not address a portion of the bill. They recommended that inspections should be conducted at source to avoid duplication. Again, I think they do not understand how inspections differ from audit, and inspections are done throughout the value chain, and you cannot confine them to one point of the value chain. That would then not be inspection. But in the main, inspections are concentrated at the end products, while audit is throughout. So the Consumer Goods Council of South Africa's comment that inspections should be conducted at the source is opposite. Actually, it's against the intention of inspection, because at the end they want it at the source. While inspection should actually concentrate on the product, the safety, the quality, the declared quality, and all of that. So at the source, you may not necessarily be. It may not necessarily the timing might not necessarily be at the time where the grading or the classing takes place. So what would you do then? Because part of the Agricultural Product Standard Act purview, it's about the grading. So if you go at the source, the timing might be such that they have not yet started grading. So why would we be confined to the source? But in any case, nothing stops inspectors to be at the source and at the end of the product. So I don't know. Maybe they were trying to limit. Maybe try to be on a limit the costs. I don't know. But we will certainly engage them to find out what is that they could be looking for. Excuse me. So the other F of the comment F of the Consumer Goods Council of South Africa said a separate audit need to be introduced, and we recommend that the department accepts suppliers' current audit. Again, this was addressed. The honorable members are able to see the pattern where, because they don't want to, the role players and stakeholders do not want to pay extra, which we understand in the current economic condition, we understand. But the minute we let that blur the work of government, we risk replacing the regulatory function of government with something else. So mandatory inspections need to be carried out by designated inspectors. We cannot, because we don't want them to incur additional costs, then we also agreeing with them, we end up not doing the work of government as thorough as we should at points, critical points as we should, because we don't want them to incur additional costs. Unfortunately, the work of government has got to happen, and of course, we would not unnecessarily go for additional fees and all of that. But again, the operative weight here is cost recovery. So if it's audit, it will be on a cost recovery as well as inspection. So that is catered for already. So work or inspection taking place within the cost recovery milieu means we'll be able to save the cost. Won't be able to, won't, like we said, there won't be over recovery. So the process of setting fees will be very transparent. PepsiCo contract, they say that there's basically they are addressing that the question about the definition of term audit, of the term audit. They say the audit, again, the term audit and inspections are not defined, and we don't understand why, because inspections and audit are two separate control systems. In fact, I spent most of this presentation defining and showing where audit is applicable and where inspections is applicable. Inspection and audit are different processes, and they're all necessary. They need to happen concurrently, unfortunately, and they have to be paid for if we have to be that explicit differently, as different control systems of ensuring that the work of government continues and the quality is assured and ensured by government. Auditing does not only apply to subsection 1 paragraph. Yes, even subsection 2 there is auditing. Auditing is also applied. The vegetable and fruit canners of South Africa, also fruit juice and canners, they say even if the audit extends to the paragraphs, this is the paragraphs, they feel that the bill does not prescribe when the executive officer or the appointed assignee should either audit or inspect or classify. And though they have a point, us including it in the bill will just complicate and will just deny the bill, the ideals of it becoming a bill, because the bill, the principal act that does not necessarily get to the day-to-day operational activities. Those would be addressed in the regulations, which will be published. And we are agreeing with those that propose that in the regulations we become clearer. And of course, the regulations are going to be also dealt with in a transparent fashion, and all the role players, interested parties, and organizations affected by the regulations will be afforded an opportunity to make comments. And this comment would actually be applicable, applied to that process. Amendment of section 3A are required in order to implement the effective and binding risk. Risk-based inspection is subject to inspector's discretion. So we cannot legislate risk-based, because company A and company B's risk profiles would differ. So, and the risk profile changes with time. So the inspector, in fact, in them drawing samples, are already applying the risk-based as is being proposed here. Probably they are not aware that the fact that when an inspector goes into a pack house, for instance, they do not go through each and every carton, each and every fruit. That in itself is risk-based. And how the inspector conducts him or herself in pack house A will differ from how they conduct themselves in pack house B. This will take into account different other considerations that will involve the quality. If sample A, if the first sample, it tells me whether I need extra samples or whether I can take 4 samples as opposed to 10 samples that I'll have to get in pack house A or B. That process is already risk-based. And there's no way anywhere in the world where risk-based can be legislated, because otherwise it's no longer risk-based, because risks vary from time to time and change, and also differ from one establishment to the other. The audit of the control system may be extended to other paragraphs here, but we again the thing one thing that we need to further on do once this bill is suspended into law is to have a workshop, because some of these comments indicate that there's a need for workshops where we clearly explain how the audit is going to be carried out and how that differs from basic inspections. And so that would require us to have a workshop, because we see these comments not as a nuisance, but we see them as a collaborative effect or collaborative work of the industry, and we appreciate that very much. It helps us to be able to render the services that we need to, the regulatory services that we need to render for the country. So we agree in agreement. This we responded to above. The bill does not prescribe when the executive officer are appointed. This was responded to above, just above here. I'm almost there, honorable members and chairperson, we're almost there. The amendment of clause 3A, the definition of inspection is necessary to provide clarity, especially with inclusion of audit. Again, we say the audit and inspections differ, but we are simplifying it that the clause at which inspection is set out, which is the 3A1 of the Principal Act, and it relates to the products, whilst audit, again, like we said, is about the management control system. So probably they were not aware. And lastly, as in the part of the bill about appeal. So ECBIS proposes that to extend the timelines for dealing with lodged appeal to promote fairness. But the comment is outside the bill, the scope of this bill. The appeals are the Agricultural Products Standard Act does make provision for an appeal. With the Director General does appoint an appeal committee in the event an organization feels that the activities or the actions of an inspector or an assignee or a representative of the assignee of the executive officer, if they're not happy with the decision, automatically they do lodge an appeal, and within a day or two, the Director General has also, to ensure that audit appeals happen as quick as possible, and mindful that these are perishable products. So the appeals are set within a week, an appeal gets set up and adjudicate on the matter. So this is this part comment by Ag-Base. Probably they were not aware, but though this is outside the confines of the bill, we do the act, the principal act does really have make provision for appeals. And in this department, the Director General, in his wisdom, has made sure that, in fact, the Act also provides for the Director General to exercise the rights to delegate the setting up of appeal boards further, so that because we're mindful of the hectic schedule of the Director General, so that gets done within a day or within a week. Appeals do get set up. Again, the amendment of Section 15D, the request that such regulations relating to the management control system, this is preempting what is going to happen, but we agree that there will be a proper consultation, and stakeholders, like I said earlier, during the regulations, we will make sure that all the interested parties are made part of the process and are afforded an opportunity to make recommendations as and when the process unfolds. And this, obviously, it gets published, regulations get published up to the WTO process. So we'll do a thorough work, and we are known in this department, especially this unit, is known to have updated regulations. So this is work that we intend doing and will definitely do. Promulgate this about regulations, so we agree, but this is, in fact, this will keep for the time when we will be commencing with the regulations. That's after the bill, if it ever gets assented into law. Once the bill is assented into law, automatically would move into regulations, and the comments like this would then consider them. Then we don't find them futile, and would really definitely engage them. The designation of any assignee for the management control system shall be done, because here I think the National Chamber of Milling is just anxious about who the assignee is, and for audit. Already they had a go and had not an altercation, but some uncomfortable to and going, throwing and toing and throwing with the inspection assignee. So basically, they're just cautioning the department against a possibility of another challenge. So we will definitely carefully address the situation better, mindful of what has just happened. These are just general comments towards conclusion, honorable members, honorable chairperson. These are comments which we also did not want to just throw out. We consider them efficiently, and we would, as best as possible, see how we accommodate them. For instance, Milk South Africa say, make it the proposing that it be made compulsory for service level agreements between minister and assignee. Of course, the Act that does make that provision. That will be done. These are just general comments. Interested parties cannot be interested parties cannot protect their rights unless it is known that the contents, of course, that part we know. So the service level agreement, the performance agreement, even better, of the assignee and with the minister will take care of that. Consumer Good Council here is asking for, APS Act has brought with it several changes for the industry in general, and our members in particular, relating to, for example, the appointment of assignees and unrestricted fees. It's a general comment, which unfortunately it was unavoidable that we bring in the issue of the audit and the management control system, and the need for us to test any claims made. Unfortunately, we couldn't avoid this process. These are general comments which are not necessarily addressing specific sections or clauses of the bill. Quickly, South African organic sector, here they're saying, with reference to organic regulations, we do not, where do we stand? Basically, earlier in this presentation, we spoke to them asking for the government to consider them and make them probably an assignee or such or related. But again, this is again talking about the regulations. So the regulations on organic produced products will be promulgated, like I said, after the bill. So that will be addressed at that stage. So I think the organic South African Organic Sector Organization may need to just wait for that process, but we'll keep this comment handy when the process ensues. PepsiCo, they want us to provide an increased, continuous, and express oversight on the direction, the direction mechanism for executive officer. Here again, maybe they were not aware. Again, this is just a general comment, but we still find them very important. But the Act makes provision for the exercise of power of oversight by the executive officer. This is the designate of the minister in the Act. So the minister is represented by an official of government with the title executive officer. So that executive officer presides over the work of the assignees. Again, these are general comments. They're not necessarily addressing any portion of the bill. Like I said, we will consider them, like I said. Primario, provide for increased continuous express oversight. Again, the same situation is above. The executive officer provides oversight. In fact, the courts have affirmed this responsibility when the sections of the Act were challenged in courts. So they actually affirmed the process that executive officer has got to preside over or perform oversight role over the work of the assignees. Other than that, this again, honorable members, we are addressing the additional general comments, which are not addressing any section of the bill, but we take them. They are very important, hence we are responding to them nonetheless. Members have implemented their own internal, we spoke about that, ISO 9001, organic organization that certify already their product organic. That's the work that they're doing to further the ideals of the organizations, but we will still have to do the work of government, which becomes primary and supreme. Theirs become additional, and we would accommodate them. Of course, we would appreciate and encourage any sector of this economy, agricultural economy, to self-regulate, but that does not take away the work of government. Recommended that there should be further oversight, as in the case of PPCB, in finalizing determination of assignees, of course. But this case law we are citing here just affirms what is currently happening. And of course, these are recent court judgments where the executive officer, EO, the executive officer, has to perform the supervisory role in these matters. Tiger Brands, same about basically the caution against the assignees and the department having to recognize their, we call them private standards. So we will, but we cannot replace government work with such. We will definitely consider those. These are the responses that we made. And this has been a marathon, and we tried to, as best as possible, cover it within an hour. I think we are in 2 hours, and I think we did. Thank you very much, DG, back to you.
Thank you, Desirability. DG. Tate Ramasodi.
Sorry about that, Chair. We have got to make the submission, and we made a very long presentation on the matters that are at hand. Maybe a few issues that I thought Chair would need emphasis. The first one was the issue around risk-based sampling, which is by default also a setting of the current legislative arrangements, because even if you conduct a random sampling, the theoretical background in terms of your random sampling means that you are of the opinion that the risk within a sample that you have chosen or within a consignment is evenly distributed, and therefore you will have to take a look at that. The second aspect was the engagements with the industry on the legislation. At this moment, the legislation is currently in front of the portfolio committee, and the engagements that we would have would be post the engagements. But at this stage, what we are limiting ourselves to are the comments that were made by the industry on the act itself. Thank you very much, Honorable Chair. We submit.
Thank you, DG, Tate Ramasodi and Tate Serafe of the Department of Agriculture, Land Reform and Rural Development. Honorable members, with your indulgence, please allow me to not put on my video as my signal is not strong being on the road, trying to get to my flight in East London. We'll now open the session, honorable members, for questions of clarity or comments on the responses of the department. Honorable Kape.
Thank you, Chair. And let me greet my colleagues, DG and the team from the department, all stakeholders on the platform. Chair, let me appreciate in the beginning the presentation from the department. I want to agree, Chair, with the submission by Honorable Masipa earlier on. And this is what we emphasized in our observations when stakeholders came to present to this committee, that they were not against the bill. Two, let me also appreciate the depth that the department went in to deal with every comment and submission from the industry. Because from my side, Chair, including those that we listen to, in addition to these ones that we see on the presentation, then answers the question that we had on the extent of consultation on this bill. Chair, as and when the department was presenting, I felt comfortable also on the stance and the clarity that we got when we started the meeting, that we need to listen to the responses of the department so that also, as the committee, we are able to tackle unanswered responses from the comments of the stakeholders in order to have validation when we deal with the motion of desirability. So, Chair, from where I am sitting, I looked at the intention or the purpose of this bill. And from the engagement to the responses that I have today, the issue of quality tops the list. The issue of management control systems that will ultimately also deal not only with the domestic products and also assist us with the imports is very key, including the possibility of expansion of agricultural products. And I'm sitting here and thinking about the agro-processing master plan. But if we don't control, if we don't ensure quality, what will happen? Because day in, day out, every hour, agricultural enterprises are geared towards agro-processing and producing more products. And this bill then becomes very key, which then means, to me, it is a very broad kind of scope that would need something to be put in place for control and management, for audit and inspections. Because if we don't start somewhere and think we can consolidate everything at a go, it will not be possible. Like I'm saying, every day, every minute, you see new products on the market, on the shelves and everywhere else. But Chair, my comment in brief is that the department does not only reject everything, there's agreement on some of the comments and submissions, there's explanations, and in a way, there's also indication that where there are gaps, they can be addressed through regulations, and that is where we need to put our emphasis as we do oversight. But in all fairness, Chair, my take is that the bill is balanced in terms of your consumer protection and a fair trade. So I would say, Chair, I am relieved. I had issues around the assignees as presented. I had issues on cost of recovery that is indicated today that is on statutory basis and not only on ancillary cases. I had issues on the audits, as and when the presentation was done, I got clarity. So Chair, I am good where I am seated. Like I'm saying, there's balance on what is important for us to play oversight on, that is your consumer protection, as well as issues of fair trade. Thank you, Chair.
Thank you, Honorable Kabe. The Honorable Mamum Babama.
Enkosi Sihlalo. And thank you very much to the department for a very comprehensive response to the comments of the stakeholders. I don't have a problem at all, Chair. I think I don't have any clarification questions. I think the department has really dealt with each and every concern in detail. And so far, I am satisfied. I am a bit worried about our procedure, but I hope you will be able to take my point of order later on if I feel I need to take it. I'm just worried about procedure, as Ntate Masipa was saying earlier. Thank you.
Thank you, Mamum Babama. The Honorable Ntate Matthias. Ntate Matthias. Can we also ask the presenter to remove the document on the screen, please? Memasho, the Honorable Memasho.
Good morning, Chairperson, and all people on the platform. Chairperson, I'm sorry I won't put my video. We are on load shedding this side. I don't have any comment but to say, Honorable Melchape has covered everything, and we are happy with the presentation from the department. Definitely sure they have done a professional job. Thank you very much, Chair.
Thank you, Honorable Memasho. The Honorable Ntate Masipa.
Thank you, Chair. Once again, good morning to our colleagues from the department. Chair, I don't normally do this, but I'm going to say to Dr. Serache, I love your passion, and thank you for really making this, response, the clarity around your response is so clear to all of us. And I think I must say, well done. But I think the one area that I'm satisfied with is the assurance that the department is obviously considering engaging with the sector to really educate around the bill and obviously providing the reassurance on issues that were raised obviously by various stakeholders. So that for me is very important, Chair, and I think I would welcome that obviously, supported by, engagement should be regulations, because the definitions that carry a meaning to yourself must not necessarily mean that it can really be understood in general, but it must meet the legal terms and obviously be able to stand the legal testing. So I think the wordings are a bit of a challenge, and many have raised, wording like the assignee, the way it's defined, and the management control system. Chair, the one area is that obviously the management control system, the way it's defined, the way it was put in by Desirability was that this was obviously to address the organic producers, but obviously it attracted the attention of other producers as such. And I think that is the area that I would really suggest that they really engage the stakeholders. The assignee obviously is an issue that was raised quite strongly by, I think it's the Premier. They have raised it the way that it was underdefined, in the sense that it made some exclusions here and there, which they felt that the definition must really ensure that it encapsulates those areas. I think that Desirability kind of addressed it, but I think it is very important that that is taken care with the industry. So furthermore, really, I think in terms of this language issues that he says that, I think he says that here is a challenge of question of language complexity, but I think in terms of the bill or the law, there must not be a language complexity, and they must just really try and take out those language complexity in terms of the regulations that they will be putting together and ensuring that everybody understands. So, Chair, another point that I thought it is very important on the control management system, and I'm going to go to the definition that it is as it defined by the Act. I just want to go to it quickly. Sorry, Chair. The control management system. It says means the principle of the manner or method of production which may be claimed through the use of a name, word, expression. So the question that I have, maybe that Desirability will just help me here. Are we trying to also address the issue that the department raised with some of the organic producers that were naming their products being a burger, a vegetable burger, and so forth and so forth? Are we trying to also address that? That's one point that I want to really get clarity around. Further, in terms of the definition, it talks about the word, expression, reference, particulars, or indication in any manner, either by itself or in conjunction with any other verbal, written, printed, illustrated, visual material in respect of the sale or export of a product. So I think here is something that I thought maybe, to just get clarity, that sometimes when I read this word, this definition, and I read it 2 or 3 times, I got a feeling that it also go into the consumer protection kind of extend into the consumer protection. But maybe the question is, where do they really kind of hand over to the consumer protection side in terms of this particular bill, to just ensure that, they don't overlap each other. And I think some of the industry experts also made the point of Consumer Protection Act being addressed in this particular bill, just to make sure that that is addressed. So the other question, Chair, is that obviously public hearings took place with regards to this particular bill. I just want to gather from Desirability whether during these public hearings, before they actually drafted the bill, did they get the similar concerns that were raised? If they got the similar concerns, did they address them, or did they engage with the industry concerns? Because you will remember that the industry also highlighted the importance of engagement, that maybe we need to engage more on the bill, in terms of the practicality, the implication, the application of this particular bill, because there were also a number of court cases. But I see that you are addressing those in terms of the responses from the department. Yeah, and I think finally, really, in principle, I don't think that the industry has got a problem with the bill, but I think the wording and the definitions must really be very clear. And obviously, before ascending to, once it's ascended into law, regulations as to how some of the wording are going to be operationalized on the ground is going to be really, really crucial. Thanks very much, Chair. Those are my inputs in terms of the bill.
Thank you, the Honorable Dr. Masipa, the Honorable Baukaba.
Oh, thank you very much, Honorable Chair, and greetings to everyone. I won't waste your time, Chair. I'm comfortable with the processes and the explanations that have been provided. Otherwise, thank you very much, Chair.
I think succession plan will have to kick in now.
Looks like the chair is cut off. Thanks, Honorable Tapa.
I was covered, Chair.
Yes, I heard you. Can we then move to Honorable Montwedi? Tate Montwedi.
Morning, Chair, and morning to all other honorable members, including the team of the department led by the DG. Chair, I've heard as the presentation was being made, there are instances where there are agreements between stakeholder submissions and the department, where the department agrees that they managed to find one another there. But my worry is that the department says that all of those issues where there are agreements, or at least some, those issues would actually be covered under the regulations. And I have a problem with that. One, we know that regulations do not get tabled in Parliament. So there's a little room for us as the committee to ensure that those issues are covered, Chair, when they would actually be dealt under the regulations. Number two is that what would be the problem if some of those strategic issues are included in the bill, so that we get to actually ensure that those issues are covered in Parliament. And number two, Chair, just as a matter of principle, what guides the department on matters that should be in the regulations and not in the act, or vice versa, Chair? And I think just lastly from me, Chair, is that it's important that as we pass this bill, the bill that we get to pass must be very clear, not some bills with very ambiguous and without, they must not have any gaps, so that they must be clear in terms of what is it that they seek to achieve at the end of the day, Chair. Those are my small submissions, Chair. Thanks very much.
Thank you, Honorable Tate Montwedi. Agbare Breed.
Dankie, voorsitter. Chairperson, I almost want to say that the Honourable Montweri took the words right out of my mouth, specific with regards to the issue of regulations. And I have to say, I share the sentiment of the Honourable Montweri. I'm also worried, and my questions were very much the same in terms of why are we referring and why are we saying that they will rather be taken up in the regulations instead of the Act? Is there a specific reason why we are rather proposing to include them in regulations and not the Act? What is the justification thereof? Because my fear is the exact same, that come the regulations, Parliament has no insight, no stakeholder needs to be included or asked about those regulations, and then we will actually not see those proposals be made. And would it be, what would the material impact on the actual bill be to include them? I mean, I don't think it would hurt. So that would be my proposal. Then, Chairperson, in terms of the assignee, and I heard what the Honourable Masipa said, and to an extent I agree with him, but I would like to find out, we received, I think, all of the inputs that we received orally had issues with the assignee, and the department said, I think on the first or the second page of their document, they said that they explained what is meant, and they explained that it is already covered. I would like to find out why don't they want to, if further explanation is what is required from stakeholders, should we not, even if it might be a duplication, as they say, should we not include it for clarity's sake in the bill, to ensure that we do not have misunderstandings? Chairperson, I'm worried about all of the times that the department said they misunderstood, because this creates the impression that the bill is not right. The bill's wording is not right. Because if stakeholders, the largest stakeholders that have to deal with this bill, are misunderstanding, then the bill is not written correctly. Because I think a bill should be clear in terms of what it means, what its intent is. And my fear is, Chairperson, that to not address clarity seeking information, not addressing those definition issues, for example, that the stakeholders had, we will actually not be doing justice to the bill. And I think it was Honourable Masipa that said we then need to have training for the stakeholders. We need to provide clarity of that. And then, Chairperson, my last input would be, there was a lot of confusion between inspection versus audit, and what is meant by the one and what is meant by the other one. And maybe Evan Tatisarage can maybe just indicate, would it be possible to include a definition, or is it already included in the Principal Act? Because that I pick up is something that I think we must address, and we must include either in the bill, or I would propose in the bill, just to provide that clear-cut clarity on that. And I would leave my comments at that. Thank you, Chairperson.
Thank you, Akbar Breed. The Honorable Memahlaji. The Honorable Memahlaji. The Honorable Mr. Kruger.
Thank you, Chairperson. Yes, and thank you to the department for a very informative presentation. And as my colleague stated, it was very, very informative, and thank you for a good job done. However, Chairperson, small businesses' biggest concern in South Africa, or the biggest problem, is the ease of doing business. And it was mentioned in the previous, with the stakeholders, meetings with the stakeholders, that red tape and the ease of doing business, this bill will make it much more difficult there for the small businesses to do their business. And another concern is then that the CCS was done in 2015. And we need to have an assessment like this before we look at this bill, and finalize this bill, especially a red tape assessment and the impact that red tape will have, especially on small businesses and small scale farmers, and in the agribusiness as a whole. So I just want to ask the department, where did they talk to red tape, or what are they going to do to reform red tape in this bill? Thank you, Chair.
Thank you, Honorable Bao Kruger. Dabezita Kosenku. The Honorable Tabekolu.
Chairperson, I think he had to leave at 11 for a physio appointment, if I remember his WhatsApp correctly.
All right. Thank you, Akbar. Any other honorable member on the platform who have not recognized wishes to pose a question? The Honorable Ndate Masipa, is that a follow-up?
Chair, it's just one point that I forgot to make. Chair, would you allow me to?
Please go ahead.
Chair, the new border management authority is in place. And I just wanted to get the feedback from the department whether these changes are also addressing or are in line with the new border management authority in the working, and if there's going to be certain impacts that might impact the bill, just maybe to just give us assurance that there's not going to be a problem when it comes to, like Mr. Kruger said, ease of doing business with the new border management authority. Thank you very much, Chair.
Thank you, Honorable Ndate Masipa. Any other honorable member on the platform may wish to pose a question? With that said, honorable members, on my side, if there isn't any other further questions, it seems there isn't much to raise since the department has responded to all the issues extensively. The main issue remaining is on having a more harmonized system, which will have no duplications and which is beyond the scope of the bill, but rather the food safety regulatory system in its entirety. Lastly, I'd say some of the issues can only be dealt with in the manner in which the legislation will be implemented. With that said, honorable members, I may pose maybe one or two questions in regards to the presentation. Of the 190 products the PPCB handles, what is the average volume that they handle? Can the department provide a breakdown by type of produce and by region or province? Based on this, honorable members, can the department also comment on the products and regions that has room for further growth and expansion especially for new entrant farmers. And lastly, based on the enactment of the Africa Continental Free Trade Area, what is the potential for growth in this market? What is the department or the key enablers that the department think will be required for this? Thank you. We'll now hand over back to the DG, Ntate Ramasodi, and Ntate Serage, and the officials of the department for responses.
Thank you very much, Honorable Chair, and thanks to the members of the Portfolio Committee on Agriculture and Reform and Rural Development for very insightful comments. And we would like to thank you also for the comments around the detailed responses that the Portfolio Committee has had the opportunity to receive from the department. As indicated earlier on, Honorable Chair, on the platform we have got colleagues who have been leading in terms of the engagements on these consultations. And I would like to hand over to Mr. Makafola, who will take us through all the issues that have been indicated, except the issues that were reflected upon by Honorable Chair and I think Honorable Kruger. The rest Ntate Makafola will respond to. I would like Ntate Serage to respond to the issues that Ntate Makafola may not have given attention to, but with specific reference to the Border Management Authority. And there were legal issues that if Ntate Makafola may not have responded to, Metshepo Matlaela would respond to. And that specifically are questions that came from Honorable Breed and to a great extent, Honorable Masipa, on the issues around regulations and the specificity and justification of having certain provisions in the regulations other than in legislation. I think it will also be important because in listening to the inputs that came from honorable members, there is a view that regulations within the department are not consulted. There is a process of consultations. We also do consultations with the WTO. I would like Mr. Makafola just to pause on that level and give that outline of how we also consult on those. With your permission, Chair, I will request that we start with Mr. Makafola, followed by Mema Tlaela, Ntate Serage, and if there are issues, I will deal with them, specifically the issues that were raised by the Chair. Thank you very much, Honorable Chair and honorable members.
Thank you, DG. Ntate Makafola, you may proceed.
I'm trying to, yes, Chairperson, I'm trying to, am I audible now? Hello?
Yes.
Hello, am I audible? Can you all hear me?
Yes, we can hear you.
Yeah, thank you very much, Chairperson, and thank you very much, DG. In my response, let me start by saying that it has to be borne in mind that most of the submissions made do not necessarily relate to what is contained in the bill. In fact, issues that have been raised specifically around the concerns on the assignee and the appointment thereof are actually emerging from the existing act. The central issue that was actually introduced in the act was essentially around management control system and auditing, and linked to that was then the appointment of the assignee that may be able to undertake auditing in that respect. But all the same, all of those issues that have been raised are sitting in the current act. I just wanted to preface my answer with that, so that we understand precisely that the bill as it is now, the actual focus of the bill is centrally on management control system, and attended to that is how then you actually authenticate those claims that relates to methods of production through auditing. And auditing would then have to be undertaken by an assignee. That's how the assignee then came into the picture. But assignee in the current form and the complaints that have, or concerns that have been raised are still concerns that are in the current act. Now, in response to Honorable Masipa, in terms of management control system, whether the claims that we are referring to pertains to the issue that is before the court in terms of beggars and all of these things. No, beggars are literally class of products, not necessarily pertaining to methods of productions. So those are the question of classes of product that are misused for products that may not necessarily be covered by regulations. That is the difference. Otherwise, what management control system pertains to is methods of production that, of course, could be organic, free range, and any other, even halal for that matter, if you want to put halal into the mix, for as long as it has something to do with how the product has been produced. The question of consumer protection, yes, there is an overlap, and correctly so it has to be, because the legitimate government purpose of the very act is to ensure that there's fair trade among traders, in the sense that you bring about a minimum standard that should be complied to, and that minimum standard should be complied to by all of those people who will be putting their product out for sale. So you then create that level playing field by a way of coming up with standard that should actually be conformed to. But equal to that, that standard is then going to give the required or requisite protection to consumers, that indeed what they are buying is the kind of product that complies with what has actually been stipulated in the standards or the regulation. So it has an element of consumer protection in that you have to protect the consumers from misleading product. And that remains a common theme in the Consumer Protection Act, as well as in the act that is administered by the Department of Health, which is Foodstuff and Cosmetic Disinfectant Act, in the sense that you are actually protecting consumers from different aspects. The other one relates to grading the classes of product that are actually being claimed. That if you are saying this is grade 1, it is grade 1 because it actually complies with the set minimum requirements. And therefore, consumers are actually being protected from people who may actually sell product that may be substandard. So if you look at Consumer Protection Act, it's an overarching act, and it actually recognizes subsidiarity of legislation. So in other words, you take into account that where there is an aspect that is addressed under the APS Act or any other act, the overarching act, which is Consumer Protection Act in this case, do recognize that. And in terms of BMA, I think the act as it is now, and I think we know that there are different departments that have actually earmarked for certain functions that are going to be falling under BMA. And we do know that in terms of imported product, which inspection that is going to be happening around ports, the executive officer is responsible for carrying out. That is not necessarily the mandate of the assignees. As such, the inspection will be carried out by inspectors, as indeed they are being carried out by inspectors as we speak now. So those would be possibly part of those personnel that are going to be ceded to BMA once it is operational, that is under agriculture. So the act will certainly not be affected. It will certainly be enforced as it was enforced, except to say that probably the umbrella organization would have actually changed. But the same function that were actually conveyed under the act will certainly be the kind of services that will certainly be delivered. In terms of Honorable Muntwedi, how is the formulation of regulations informed? The act as it is, the act normally, I think all legislation actually state the what. You find the what, you certainly find the what, and that's what we call prescribed. In all of these acts, you'll find that some actions are prescribed. And that's how, the how part of it is contained in the regulations. So in the act, you'll find an empowering provision. So what actually guards the consumers, or even promulgations of regulations that may not necessarily be in sync, is whether there is an empowering provision within an act. And that empowering provision is what actually gives birth to the how. Now, what we have in terms of management control systems, that it is a prescribed, and we are saying so, it says prescribed manner of productions and all of these things. So prescribed by its very nature, it means by regulations. So in the regulation, you'll then set out as to how is that going to pan out. What is the regulations that are going to be attended to organic? What are the regulations that are going to be attended to free range? And the manner in which they are going to be realized. That is going to be set out in the regulations. And for us to be, so that we don't say that all of these regulations are done in terms of budget. I think that is national cause that we follow in terms of Section 33 of the Constitution of ensuring there's national justice in terms of undertaking your own regulations. So there's vast consultation that the regulations in terms of budget sets out time limits for consultations and what it is that you can do so that your regulations are not necessarily impinging or actually offending against the provisions of budget regulations or budget or even the Constitution for that matter. So we do actually consult vastly with the industry. We gazette our regulations, we gazette our draft, we even consult internationally. And once we have actually cycled on a national or this sort of consensus in terms of what we want to actually put out as regulations, we then go internationally and say, this is the actual measure that we want to introduce. See to either this measure is not necessarily creating unnecessary technical barriers to trade because we're dealing with TBT matters. And they'll then comment and we'll then look at those comments. If those comments seriously alters our regulation, we then go back to our own national stakeholder to say that, look, we have this consensus from international community. Can we relook at the regulations? So that is the kind of process that we traverse in before we could actually put out our regulations as the final regulations that are lawful or subordinate to the act. So members can actually rest assured that there is no regulation that will certainly be published or gazetted that will certainly be beyond the scope of the act, or that would certainly not be in line with the constitution of the country. So that's how the regulation, so there's no way. The act informs the regulations. The regulation, if it is not necessarily informed by the empowering provision of the act, it is not supposed to be published. It's as simple as that. It becomes ultra vires because it does not have the norm from which it actually could derive from. And in terms of the comment from I think some of the comments that were raised by Honorable Bria, I think I've answered it under the regulations, that the regulations are actually as such. But secondly, the issue that you raised in terms of differentiation differentiations of auditing from inspection, that should actually be taken into account. The act as it is, it actually sets out in section 3 the manner and circumstances under which inspection ought to be carried out. Now, if you are having such an exhaustive section that sets out circumstances, gives you all of those things in terms of how inspection ought to be carried out. The question is, are you going to delimit it by coming up with a definition that may actually run counter to the existing section 3, which section 3 capital A, which details precisely as to how inspection ought to be carried out, simply because you've introduced an element of audit, because currently we don't have a definition of inspection, but inspection is generally understood because it is actually been properly described, well exhaustively described in section 3A. So if you are to have that definition, which there's nothing wrong with having it, but it may actually undermine or not necessarily give the necessary expression to section 3A. As it is now, it is all encompassing. It actually sets out the manner in which inspection ought to be carried out, circumstances and all of those things. So I think that section 3A would actually be dwarfed if we were to introduce a definition that speaks to inspection, because inspection is well defined or well described in section 3.1A. What we then did in terms of audit, because it's also a differentiation, because if you look at what we did in terms of 3A, the introduction of that clause was merely to say that audit as pertains to management control system, which is a system on its own. Production, any production system, any production method is a system. There are inputs that you have to use. that ought to follow certain ways. There are manner in which you should actually handle a certain production system. And therefore, you need to audit each and every facet of that production system. So that is why when you then actually introduce audit, there has to be that kind of definition that talks to management control systems. So there is no doubt, there's no gray area. But as for inspection services, it is well detailed in section 3, capital A of the current act. And I think in terms of what I was supposed to deal with, I think I have actually, unless of course there are questions that I've not covered. I think DG, I've just covered exactly what you mandated me to cover under the responses from the department in respect of what you mandated me. Thanks.
Thank you, DG. Good morning, members of the committee, Chair. Mr. Makafula has covered quite extensively on the issues around the regulations and the act, why some issues go into the regulations and some others into the act. What he has not responded to from Honorable Briet was the question about the issues around uncertainty in the use of language that we have used. That seems to have come up quite a lot from a lot of the comments. What we have agreed with Parliament's legal services is that we're going to sit and clean up the bill. You will have noted that the department has made quite a few concessions in terms of clauses that must come out, words that must be removed. So that exercise of cleaning up and ensuring that the language is not open to interpretation and does not cause any confusion, those will be dealt with in our discussions with Parliament's legal services, which is being organized for Thursday. Thank you, DG.
Dr. Sarafe.
Thank you, DG. I think the issue around PMA, which was left for me, has been addressed by Mr. Makafula. There are no, we don't expect any challenges. So the confines and the scope of the amendment and or that of the principal act do not really pose any conflicts between the arrangements. So we actually are participating in the BMA, Border Management Authority process. Management Authority is to extend our work at the sterile port side. So as soon as it's outside the sterile port, it becomes still our responsibility. But we will have, we already are drafting agreements or service level agreements between the department and the Border Management Authority. So theirs is just to extend what we are currently doing. Other than that, I think mine is just to recommit honorable members and honorable chairperson that we don't see this as a one-way. So as soon as we're done with the process, we will be engaging all the role players, stakeholders who made representation, just so that we, again, once the process that Mayor Makhala has referred to concludes, we'll definitely then go back to them and just to comfort Honorable Briat, that we will ensure that we speak and agree with them to show them how their comments are captured in the final text. So we don't foresee any problems. And so other than that, I think without belaboring anything, thank you very much, DG, and thank you very much, honorable members. We are covered. Thank you.
Thank you very much, Ndati Chair. If you allow me, let me respond to the issues that were raised by Honorable Priya and the Chair. The first one being the ease of doing business, and a reference that Honorable Kruger was saying that maybe there's a lot of red tape and there needs to be a red tape assessment around the socio-economic impact assessment that was submitted based on the act as it was. And I don't think that in between there has been a shift on the issues that are at hand, Honorable Kruger. That is why that was submitted and that was checked. with the colleagues at the DPME before submission. However, I'd like to pause on the issue around the red tape, which simply translate to excessive bureaucracy. And I've looked at the Act and I don't see it as excessive bureaucracy. And I'll name two instances where this is applicable. The first one is that this is a compliance issue. And any compliance that we have got to look at has got to be looked at two opposing sides. Firstly, as rightfully indicated by the industry, on the cost of compliance. But equally true, we have got to look at the cost of non-compliance, which would then go to the consumer and would also go to the credibility of the country and the credibility of the systems that we are running. So any reference that we have on the cost of compliance has got to be offset and has got to look at the opportunity costs that lie elsewhere, especially around the credibility of our systems and also the cost that it is to our consumers. And in this case, any level of non-compliance to quality standards, we would know what it would imply. It would imply that the consumers are not getting what is worth of what they are paying for, and the consumers are also shortchanged in terms of the claims that are made on any product that is being presented to them. And I don't think that at that level, it should be a very difficult task in terms of setting the two against each other. Where the reference comes in and we look at the cost of compliance, there were a few instances where the industry had raised to say, there are current existing systems and the systems give assurances. I would say that each and every system that we have has recognizes a level of equivalence. Now, equivalence would say that if you lose one system, if it gives you the very same level of assurance than like the other system that is in place, you can make that consideration. And the Act is flexible enough to give the executive officer or the people who have been assigned by the executive officer to do that work, to take that level of engagement on the regulatory mechanism that is provided for. Now, the other area, Honorable Kruger, that is very important is the stage of development when it comes to a regulatory system in a country. We would, as government, also like to have self-regulation. But at the stage of our growth, where there's a lot of infancy in different areas of work, we need to ensure that government is the sole responsibility for minimum standards, and we will implement those. Because if we go for self-regulation, when the stage of development is different at different levels of our industries, then we will be doing a disservice to the regulatory system that we have in our country. I thought I should just address those areas because they also reflect the ethical citizenship of those who are being regulated by the different legislative pieces that we have in our country. Going to the Honorable Chair, yes, Chair, you are right. We need to have a harmonized system. And in that harmonized system, I think Chair will recall that there are deliberations around the food control system, similar to the Border Management Authority, where we can have a food safety authority or food controls authority that will ensure that we have got a harmonized food safety regulatory system. And I think when the time is ripe, the engagements, as the Honorable Chair would recall, as done by the previous portfolio committee, would serve, and we could see how do we then envision this new food safety regulatory system within the confines of the current systems that we have, lying in different departments, of course. The products that the Chair has indicated we have got to get from the PPCB, will do that. PPCB has got a very good system in terms of there are different regions. PPCB works on regions, not necessarily being cut according to provinces, but we can be able to cut and dice and indicate that these products would find room in terms of growth within the agriculture and agro-processing master plan, Honorable Chair, also within the sugar master plan and also the poultry master plan, and we will compositely deal with those. I think if we come to the Africa Continental Free Trade Area, Chair is correct. There is potential for growth. But what we have done, because TBT issues and SPS issues are core to the engagements within the Africa Continental Free Trade Area. There are different annexes that deal with issues that have got an impact on the areas of importance. Like we discussing quality issues, they are now regarded within an annex that deals with technical barriers to trade, and these have been articulated, and there's that annex that would allow us to go into the AFC FTA. And you would recall that at some stage you also indicated we have got an annex that deals with sanitary and phytosanitary measures, and also an annex that deals with the rules of origin, so that when we trade in these products, we are able to do that. So all those areas, the groundwork in terms of the frameworks have been done, Honorable Chair, and in line with the presentation that we have made on the opportunities for the Africa Continental Free Trade Area, we will be able to access these markets. I think that would conclude our submissions to you, Chair, and suffice from our side to thank the Chairperson of the Portfolio Committee and the members of the Portfolio Committee for the incisive inputs and also thought-provoking questions that they've posed to us. If there are any other questions that we might not have responded to, Chair, similar to the products on the PPCB, we will respond in writing. Thank you very much, Honorable Chair and honorable members.
Thank you, DG Dr. Ramasodi, as well as the officials of the department for your responses. I think we've been enlightened, honorable members, and empowered as to how the department is seeking to approach this bill. And we are happy to have been taken into confidence on these issues. I want to therefore thank all the officials of the department for their presentation and their responses. Honorable members, according to our program, we need to adopt the motion of desirability as a means and approach to dealing with our work. I've also checked in terms of the legal services and the state law advisor in order for them to start working on the proposed amendments that the committee will make. We are supposed to adopt a motion of desirability. So I'll put it to you, honorable members, in terms of the engagements we have had with stakeholders and with the department, so that we may be able to further deliberate on the bill in the next week's session. But before us then would be the motion of desirability on the Agricultural Product Standards Amendment Bill. I will read through it so that we are all clear as to where we are. It reads as follows: the Agricultural Product Standards Amendment Bill, B15 of 2021, having been referred to the Portfolio Committee on Agriculture and Reform and Rural Development for the consideration and reporting in the compliance with the National Assembly rules, 9th edition, Rule 286. The rule reads as follows. 1. If a bill has been published for public comment in terms of Rule 276 or 295, the Assembly Committee to which the bill is referred must give interested persons and institutions a comment on the bill. 2. If the bill has not been published for public comment and the committee to which the bill is referred considers public comment on the bill to be necessary. It may, by way of invitation, press statements and advertisements, or in any other manner, invite the public to comment on the bill. I'd request honorable members to mute your microphones. Rule 286, subsection 4, further reads as follows. The committee, Roman figure 1, after due deliberation, must consider a motion of desirability on the subject matter of the bill, and if rejected, must immediately table the bill and its report on the bill. And J, if the motion of desirability is adopted, must proceed to deliberate on the details of the legislation. Honorable members, there is the motion of desirability. Any move for the adoption of the motion of desirability? Any hands? The Honorable Memato.
Thank you once again, Comrade Honorable Chair. I stand to move for the adoption of this conversation that we have been having this morning of disability. Thank you.
Thank you, Honorable Memato. Moves for the adoption of the motion of desirability. Any second, honorable members? Any seconder?
I am second, Chair.
The Honorable Kapa.
Yes, I second my honorable Chair.
Thank you, Honorable Kapa. Seconds the adoption of the motion of desirability. Honorable members, with that said and done, we will therefore proceed with our deliberations on the bill as it is required of us, and we will be able to invite the legal services from Parliament and the State Law Advisor to be able to come before the committee, and we will then be able to deal with the bill sentence by sentence or line by line. We'll await further notices in terms of our session next week, Tuesday, in order to deliberate on the bill. That brings us, honorable members, to the end of our program or agenda of today. I therefore want to take this opportunity to thank all honorable members for having participated in today's session and for always being robust and engaging with the matters at hand. I want to thank the officials of the department who availed themselves for the engagement with the Portfolio Committee on Agriculture, Land Reform and Rural Development, and all other stakeholders and interested entities that were part of the meeting. Most welcomed, and we are grateful that you continuously have interest in the work that the Portfolio Committee does. I want to also take this opportunity to thank all our staff, the Secretariat, the content advisors, and those that work in the shadows to ensure that we are able to do our work and see these meetings through on virtual platforms. I want to remind honorable members, we do have a hybrid meeting, plenary meeting this afternoon at 2 o'clock. So please log in on time. Thank you all. Have a wonderful day and a great week ahead. The meeting stands adjourned. Thank you, honorable members.
Thank you, colleagues.
Thank you, Honorable Chair.
Let's also thank the awaiting chair.
Okay, thank you, Tati Masipa. I know you want to be thanked individually.
Succession plan, chair. We work on succession plan. We can't leave this country, without succession plan.
All right.
Yeah.
Have a wonderful day. See you in plenary. Yeah?
Travel safely. See you, Nana.
All right.
Sure.
Chair, uphumile. Shabasin. Shabasin.
What is a pumile push?
You. Okay. Tshilo. Sayomelwa nguwe ke eRhawutini asiyithini.
Phumla man, here, Phumla. Wait, man, let people leave. Stop recording.
Recording stopped.